defense requested and have gotten a trial in this case before a jury. Is not before the court as a bench trial. So that means that this court is not the trier of fact. And the standard, as you all know, for a motion for directed verdict is not the beyond a reasonable doubt standard, that what the jury is going to be determining the facts on when the case is given to them. The standard at the stage of motion for directed verdict is that all of the evidence is to be viewed in the light that is most favorable to the prosecution, and doing it in that way, looking at it in that way, is there any evidence from which a rational trier of fact could find the essential elements of the crimes that are charged. So with regard to the motion for directed verdict on counts 1, 2, trying to do these in order. So let me just do it this way. I am denying the motion for directed verdict on all counts except
There you go. We got one.
granting a motion for directed verdict as to count 59, count 60, and count 62. I do not believe that the elements of, that even viewing in the light most favorable to the prosecution, there's evidence upon which a rational trier of fact could find the essential elements of possession of those particular items. Let me say that with regard to...
Those are all Deamonte Kendricks. The 3 for Deamonte Kendrick.
Sorry, not count 1. Counts 2 and 49, again, is not a beyond a reasonable doubt standard that the court is required to employ in determining a directed verdict as to those counts. I understand the arguments, but it is up to the jury to determine credibility of witnesses, and it's up to the jury to determine what witnesses or what parts of testimony they might believe and what witnesses or parts of testimony they might not believe. So if there is evidence presented that a jury chooses to believe, which is how I have to take it in evaluating this, I have to evaluate it as though the jury is going to believe whatever is most beneficial at this point to the state's case. Which means they could believe everything that Mr. Copeland or Mr. Zachary said that would support the state's case. And frankly, they can disbelieve even an expert's testimony. And so I just wanted to add a little more with regard to what my reasoning was as to those counts. So that's, y'all know now what it is that you need to be preparing for closings. And I think unless there's anything else on those matters, that we can turn to the hammering out the rest of the jury charges and sorting out the verdict form. And I appreciate that y'all seem to have been able to determine for a lot of the overt acts, which there is not any evidence of. And so obviously those will get redacted out of the indictment. Oh, let me also say with regard to those gun charges that we talked about earlier, that I am granting a directed verdict with regard to the greater of those charges on the 133. The state even admits they don't have all of the elements for that. So those will be charged as the lesser. It looks like that Martinez case provides that even over a defense objection, the state is entitled to get the lesser charge for those counts. So that's why that's kind of, I guess, a grant of a partial directed verdict as to those counts. And those were the, well, y'all know which ones they were. I don't have them right in front of me. What were they?
52, 64, and 61.
Okay.
Those were the 130,
you.
133 ones, right? Some of them.
All right. So I haven't yet seen the proposed charges on the crimes that are set forth in the overt acts. So, Mr. Atkins, we did get, there were some additions or changes
What?
with regard to the state's proposed RICO instructions, but have you sent yet the crimes that are just set forth in the overt acts?
The pattern instructions, Your Honor?
Yeah.
Yes,
Okay, maybe we just missed that.
I titled it, Your Honor, proposed, I think, supplemental jury instructions.
All right, well, Ms. Percival will look for that. I know there are a couple of things we need to circle back on the non-RICO part of the jury instructions, but let's